to resume. While everyone's doing that, there have been some murmurings about people not being able to hear. So I'd ask you all to try your best to speak into the microphone. It's not straightforward, I know, but if you could make best efforts to do that, I'd appreciate it. Thank you.
So I wonder if you mind if I, subject to anything you had to say, just say something in a moment.
No, it's fine.
Yes.
Go on.
Mr. Wright, having made his submissions to you, came to speak to me during the short adjournment, and I wish to make a number of things absolutely clear because he's threatening legal challenge. And I want to make this absolutely clear. Topic paper 1 was published in May 2018, and however it was classified, it has formed part of the examination of the plan and was part and parcel of the Phase 1 hearings in 2019. It was supplemented by a more detailed addendum in March of 2019, which set out the considerations in much more detail, and indeed was the focus of the criticisms made after the Phase 1 sessions. And I wrongly gave you the reference, the CYC 18 to 18F. That is the reference to the original addendum from 2019, which still forms part of the examination library. The new addendum, which replaces it, is CYC 50 to 50D. Now, I wish to make it absolutely clear, the basis upon which the Council proceeds in this examination is on the basis of the revised addendum. It supersedes what appeared in TP1 and the TP1 addendum. It supersedes it for the reasons which you raised with us after Phase 1 and which we addressed and consulted upon during the course of lockdown and last year. Let there be no doubt that the material that is relevant to the examination of TP1 addendum and the revised addendum and the Greenbelt principles which are now being applied and which you are asked to consider in your examination have been available for comment and objection appropriately, and no case for suggesting any substantive unfairness can be made out in respect of them. I just want to make that absolutely clear. Thank you.
Thank you, Mr. Alvin. I'm not going to suggest we go over this ground any further, but I've made a careful note of what you had to say about that. I think I was going to come to this side of the room. Ms. Gabrielazou, do you want to go next?
Thank you. I'm going to avoid too much repetition. We do believe that in terms of today's matter overall, the policies are acceptable, but they are only that once we've got into the deeper detail coming up with the matters in the coming days and weeks. And so it's just making that point really in terms of it's almost circuitous in terms of we have to come back round to this point in terms of whether the plan is sound, and it has to be in so regarding all the matters before that final conclusion is made. And there are a lot of complexities and concerns and questions regarding various matters, including methodology to do with the Greenbelt boundaries, which we believe is inconsistent at this point in time, but that is for next week. And it's just to really make that point that until then, that final conclusion cannot be made. And I think that is what many others are saying as well today. And that is it really, just wanted to keep it simple. Thank you.
Thank you. Mr. Robin, no? Are there any other submissions? I better put my glasses on to see if there are any on their side. Ah, yeah, carry on. Sorry. Mr. Willis.
Thank you, sir. Yeah, I think there's probably a lot of things that we agree upon here with everyone else in the room. We'll probably take as read that the policies are broadly supported by most people in the room, and that there are difficulties with them actually achieving what they actually set out to achieve.
My apologies, Mr. Rees. I can't hear you particularly well.
Sorry,
Sorry.
I should bring this a little closer. Is that better? Yeah. So I think that the reasons for that will obviously be discussed in later sessions dealing with the economy and OAN, but in principle, I don't want to lose sight of the fact that we're starting with the 2012 MPPF here. We've had some fairly light-hearted, I think it's fair to say, discussion this morning about our hands being tied and carrying around dog-eared versions of this 10-year-old document, but frankly, that's a really serious situation for future planning in York. You know, it's 4 years since that MPPF was replaced, and not only once but twice. I agree with the points being made by Mary Cook and several others now on this. And at this stage, I think I could be convinced that a clear plan review policy could be made, subject to wording. But in reality, at the minute, I think we're probably looking at a situation where the plan does need to start again. And again, we'll come on to the reasons for that next week. But I think the evidence will be, at point of adoption, the evidence will be woefully out of date. And adoption, and frankly, won't be suitable for determining planning applications. I don't want to dismiss the potential for an early review, but at the moment, it seems that such an approach would result in conflict with Greenbelt policy, and I suspect that's probably why the Council is resistant to it, on the basis that obviously we know Greenbelt policy, paragraph 83 of the MPPF requires Greenbelt to endure beyond the planned period, and without making that leap to say it won't endure beyond the planned period today, it seems highly unlikely with what we know about standard method and the likely housing requirements in the future. So I think it kind of does repeat the same things as many others, but at the minute I think we've got real issues with the evidence base in terms of its age and how much weight will be attached to that plan upon adoption.
Thank you. Mr. Elvin?
I think we'll deal with those matters as they arise.
I'm content with that, but I've made a careful note of the points, obviously. Is there anyone else who wants to make a submission?
Is that what I think we now refer to as a legacy hand, Ms. Gabrielazzi?
I think you just wanted to say my name again. Very nicely, thank you.
In which case, then, I think we can, unless anyone else does have anything they want to say, we can draw things to a close for today. Quite early. Can't pretend it'll be the same for the rest of the week. I'm not entirely sure. I mean, the way we've done or the way the timetable has been done, it's sort of easing in, and then I think we get onto some more not necessarily substantive, but more complex issues tomorrow and certainly the day after. Good. In which case, then Oh, I'm sorry.
With the greatest apologies, I thought we were dealing with questions 1, 2, and 3. I didn't think we'd moved on to question 1.4.
Forgive me, I thought people had been covering them all together, but...
They seem to be very separate, sir. It's a very separate issue. And so we do have quite substantial matters to say about the essay.
Well, off you go then.
I'll do that, sir. And again, I don't want to go into detail, because clearly detail is going to be for later on. But we say, sir, that the essay is significantly flawed to the extent that it fails both the legal and the policy tests. And so we say that under a number of headings. I could take you through those headings. So, like the local plan, we say it's not based upon an up-to-date or reliable evidence base. And again, we'll amplify that as we go through the matters, but to just give you some tasters on this. Take you to essay objective 12, which deals with air quality. So what is remarkable in a city where air quality is said to be a major problem, both City Council resolutions and indeed in the local plan. So you have almost no information in front of you about the impacts of this plan upon air quality. Which means, sir, that any conclusions in the essay are almost entirely speculative. And so we do know from the SLP, and so I would draw your attention to the submitted local plan table 15.1, and indeed paragraph 15, sir, of the plan, which I should have got in front of me. I wasn't expecting to be quite here so quickly. Which deals with the impacts on the highway system of the local plan. And you'll see there that it is talking about an increase in network delay of approximately 55%. So that is clearly going to have major impacts upon air quality. So do you have it in front of you? That will have major impacts on air quality. And this is a matter which for the SA to meet the legal test, there should have been reliable information, even to high-level study. But there's a complete absence in the local plan. So transport, SA Objective 6. So again, you have very little hard information in front of you about the impacts of overall and indeed the impacts of individual proposals. And I think, sir, going into this examination, I don't think there's even agreement with the Highways England about the impacts on the A64. Again, that does mean, sir, all the judgments in the essay are almost entirely speculative, particularly on the impacts of the strategic sites. Again, sir, if you take essay objectives 14 and 15, they seem to be based...
My apologies, if you just bear with me a moment, Mr. Corsi, while my note-taking catches up. So you were taking us, I think, to
Objectives 14 and 15, which are dealing with setting of the historic city and landscape. And as far as I can read, and the essay seems to confirm this at various points, and we'll deal with this in more detail on the Green Belt. But that seems to be entirely based upon the proposition that figure 3.1 shows all the areas which are important to setting. And so we know that the Council has resiled from that position. They did so in the Phase 1 hearings. And so if you take Objective 15, you have no landscape study of which areas of countryside are important within the city and which are not. And of course, I'm distinguishing here green belt and landscape, sir, because they are slightly different. And so the second point we say, and I think this goes to matter 4, there has been no assessment whatsoever in the submitted essay of the spatial development strategy which underlies this plan. So if you recall, this matter was discussed at the Phase 1 hearings, the lack of a policy dealing with spatial distribution. And I think as a result of that, the Council actually published PM 55, which of course is text, not policy. It gives a brief summary of the new settlements trying to reduce peripheral development. But sir, when you look at the essay of those proposed modifications, that text has never been essayed. So that fundamental spatial distribution strategy hasn't been assessed, nor has its reasonable alternatives. And so the earliest, and I want to just deal with this point before Mr. Elvin actually says it is, points to the earliest, it's the latest essay of a spatial distribution strategy was in relation to the 2013 preferred options, where, sir, the strategy which was actually chosen was indeed a single new settlement, not multiple new settlements as now put forward in this plan. And that's contrary to the statement which is actually in the essay. I would invite you, if there's any doubt about that, look at the documentation, the detailed documentation on that. So in any event, a 2013 sustainability appraisal of a different spatial strategy, because of course it didn't look at things like expansion of Haxby or expansion of villages, which is in the submitted plan. That does not mean you should not assess at submission stage the spatial distribution strategy which underlies the plan. And so again, we'll deal with that in, I think, matter 4. The third point, sir, is on reasonable alternatives. We don't think this plan has looked properly at reasonable alternatives, a whole number of matters. But one of the, I think, glaring lack of any assessment is of a reasonable alternative below the chosen housing requirement figure of 790 dwellings per annum. Council has simply, everything, all the alternatives chosen have been above that. And such a reasonable alternative would obviously score very highly on in terms of environment. And so you will have to conclude on what you think the housing needs are in, when we deal with matter 3, or matter 2. And so can I take you, the fourth heading, we would say, is that the essay is full of what we would say is unreasonable judgments. I'm not taking this matter where there is maybe a balance of opinion, but where a judgment seems to be, it's totally unreasonable, sir. And when you look through the essay, what you'll notice, of course, is that there are many significantly positive assessments and very few significantly negative. And so can I take you to, first of all, to CD 008, which is the submitted essay, paragraph 6.4.44.
My apologies, did you say the submitted essay?
Yes, sir, 6.4.44. And so that's dealing with the employment requirement. It says the quite remarkable statement, economic development, and this is the 650 jobs per annum, could help balance housing and employment provision, reducing net commuting. And so you know from reading everything about housing and employment, that is just simply factually incorrect. Because if you achieve 650 jobs, sir, without also increasing housing, that will actually increase net in commuting by a substantial amount. And so that has fundamentally affected that wording, sir. You go through the various judgments on the various essay objectives for the employment provision. You will see that that has influenced the scoring of those. And so we say that the SA, in respect to the employment of that 650 jobs, is simply incorrect. It can't be justified because it's based upon that completely incorrect view. So we will take you also to, again, the same document, CD 008. You'll see the cumulative impact on pages 144 and 145. You'll see the cumulative impact of the various policies on SA06, sir. And despite what I've read out to you about congestion, on transport, it is said to be significantly positive. And so, despite the fact that we now know that the extent of development proposed by the plan will cause harm, and I won't quantify that, probably significant harm to the setting of the city. And obviously it's a matter of balance, sir. I'm dealing here with the SA, which of course is not the decision, which is not the planning judgment, it's simply setting out the factors. But under SA14 and SA15, we're told that the cumulative impact of the proposal plan will be significantly positive. That can't be so, judging if you look at the findings in relation to the strategic sites. Significantly positive is two pluses and under green. And so I've already referred you to ST27 and again the how it has assessed the university expansion, despite the fact that it is within an area which figure 3.1 says should never be developed, whatever the needs, and so that is what 3.5 actually says. It is meant to have only a minor negative impact on setting. The plan is riddled with these inconsistencies, and the SA as well, sir. And these are just examples, so there are many others as we go through. So another matter, the SA has taken no account of off-site infrastructure impacts. And so it's very, very significant.
My apologies. No account of?
Off-site infrastructure requirements. When you're assessing strategic sites, some of the strategic sites need very major infrastructure, whether you deem it off-site or it's not part of the allocated site, so that's why I'm using that term. And so, as we know, ST15, again, I don't want to go to the merits of that, but that requires a very large grade-separated junction off the A64 and a 1.5 kilometre access road crossing open countryside. And that is not, the impact of that is not assessed in any way by the SA as part of ST15. That is fundamentally, means that any judgment is fundamentally flawed for that site on which the whole strategy of the local plan depends. And finally, sir, because the council at times seems to use the essay as a substitute for evidence, is of course not that, sir. It should draw upon a reasonable evidence, it should draw upon the evidence base of the local plan. And so just to give you one example, just because a proposal or allocation may score highly on all bar one of an SA objective, that SA objective in itself, such as setting, may be sufficiently important for you to consider it contravenes national policy. And too often we see the in the council documentation is simply, well, we've essayed it and it looks okay and it's okay. That is not the same as a proper planning judgment backed up by proper evidence. So that, at this point, that's all I want to say. Obviously, these are matters we'll go into in a lot more detail when we go through it. But I wanted to give you a taster of what we will be saying about the essay.
Okay, well, before I come to Mr. Elvin to come back on this, can I just ask you about the implications of what you're saying? What do you suggest? I mean, obviously what you're saying goes to soundness, but what do you feel the implications of that might be?
Well, my understanding, sir, is that it goes to soundness. Obviously, there are two things here, planning judgment on soundness. The essay, sir, as I understand it, is a document which can be revised at this stage. So if you felt that it was inadequate, then, sir, I would have to accept that you could ask the council to revise it, but it would be such a major task, and it would require all the judgments in the local plan to be reassessed, many of the judgments in the local plan to be reassessed. I think we're at withdrawal stage, personally, sir.
Mr. Elvin, there's a lot in that, obviously, but I'll come to you.
First point, at least half of what Mr. Corsier has said does not appear in the written statement. You have 8 paragraphs on question 4, and this ranged far and wide beyond that. And if Mr. Corsier is going to advance legal submissions, which he should have advanced at phase 1, then he needs to put them in writing and to give us due notice so we can respond to them. Secondly, I don't accept his criticisms, and because these have appeared in a much more detailed form this morning, we're going to put something together in writing, I think, is the only sensible thing. He's making assertions about illegality in the essay, and that will need to be considered. But I would like to ask you to request him to put in writing by the end of this week his allegations with regard to illegality, because with respect to him, he does confuse matters of judgment with matters of law. And it's been said so many times that it's scarcely worth repeating. Memorably by Mr. Justice Sullivan in the Blewett case, adopted by the Supreme Court recently in the Heathrow third runway case, that matters of assessment and the adequacy of assessment are matters of judgment. And it's only in extreme cases that they would be regarded as so inadequate as to render the assessment illegal. And the same goes for sustainability appraisal, strategic environmental assessment. The issue in any event is an academic one, because even if you were to find the assessment to be somehow defective, despite the numerous revisions which have taken place as the plan has proceeded, the courts have made it perfectly clear, as Mr. Corsier has just acknowledged, that they can be corrected by a subsequent essay, for example, at the main mod stage, or even the final essay to accompany the adopted plan. And I don't accept that the matters are so flawed that they would warrant a root and branch reappraisal of the local plan. This is simply a tactical move made late in the day by the parish council, submissions that ought to have been made 2.5 years ago. But we will respond in writing, but I do urge you to ask Mr. Corsier to put his legal submissions in writing and to do so now, please.
I think, Mr. Corsier, but I think you probably will need to do that. You'll need to put that submission in. Is that something you're able to do by the end of this week?
Sir, if we are in hearings to the end of the week, that's going to be extraordinarily difficult for me because I have no large team, as Mr. Elvin does, sitting behind me to do anything. So I would have to, that would, by the end of the week, would be difficult. I could do it over the weekend, sir. It depends, sir, if we are not sitting on Friday, but I suspect we are going to be sitting on Friday. I could do it on Friday, but as I say, I'm doing this pro bono. I'm basically don't have a team behind me who can do this. I have to do it all myself.
Mr. Elvin, next week, are you happy with that? Or?
The later it is, the later it's going to take us to produce a response for you. But if that's what it takes, that's what it takes. But my answer to Mr. Corsier is, of course, these are submissions that ought to be made 2.5 years ago, let alone in phase 2. So I'm not that sympathetic towards the fact that it puts him under some pressure. And Fulford Parish Council is not unknown in the litigation sphere, so it's not an entity that is unaware of what it needs to do legally.
I take your point about timing, Mr. Elvin. Having said that, I do want to be clear about the points being made because I think that we need to be, and also we need to be clear about your response to them. I think it would not help us if we pressed Mr. Corsier into producing something during our adjournments. So it might need to be a little bit longer than that and be a bit more lenient in terms of the timescales. So on that basis, by tomorrow morning, that would be fine. Or maybe early next week.
Yes, of course, we're sitting on Monday next week, aren't we? So.
So I'll try and produce it over the weekend. Obviously, it depends on how long we sit on, if and how long we sit on Friday.
The thing that slightly troubles me is whether or not this is something that's going to bleed into other sessions or whether we can simply contain it to be dealt with in writing.
So a lot of these matters obviously are going to be dealt with in later sessions. So really what I was doing was flagging up our concerns, which we are going to be amplifying in later sessions in any event. So it would be, I think there will be opportunity for discussion about these later on.
The issue you see is that both Mr. Griffiths and myself and from the council side need to be absolutely clear about the points being made if they are going to come up in other hearing sessions rather than sort of struggling with the fundamentals during the hearing sessions, if you see what I mean.
I mean, what concerns me is it's a submission about legality, and I really, I mean, I can see that the substance of some of the judgments clearly is a matter for the individual sessions, but having planted his flag very firmly on the peak of legality, I do think it's incumbent on Mr. Corsier to set out in writing what his submissions are on the legal issue.
I agree. It's certainly something that we need to be crystal clear about.
Yes, sir. I'm happy to do that for you.
If Mr. Corsier, you're able to produce it for Monday, then that would be helpful before we get too far into the other sessions that it might get into. But of course, then once Mr. Elvin has seen and we've seen it, there may be a need for the council to be able to respond before we can deal with those matters in those individual sessions. Just looking at the way the timetable works. We've got employment tomorrow, yeah, housing need, and then we're looking at site selection next Monday, so it's all a bit tight.
Yes, sir, and that concerns us because we have quite a lot to say on those, maybe those 3 items. But, sir, I will do my best over the weekend, and hopefully we won't sit through the whole of Friday. So,
Yeah, look, you know, from my perspective, it's not going to be fair to the council to bring up legal points that aren't made in hearing statements at the sessions. So, on that basis, if you are going to make legal points, we need to know what they are in writing, but we'll deal with them that way rather than hearing the legal points during the hearing sessions, I think, because otherwise I think it would simply be unfair to the council.
I'm happy with that, sir. Obviously, I'm not a lawyer. I'm not actually all if the legal point is the same as the policy point, to my mind, is whether it's adequate. If it's not adequate, sir, it fails a legal test. But I don't want to debate legalities with Mr. Elvin. I'm sure he knows much more than I do about that subject.
Mr. Elvin, does that sound reasonable to you?
I'm quite happy to have it put in writing. I mean, it may illustrate the fact that one should be careful about making allegations of illegality when it's actually issues of judgment. But if he puts it in writing, we can consider them and give you a response. But I'm grateful.
I think yes, you highlight the point that where a judgment tips over into the point of irrational or illegal is a difficult one. But if you can work on that document so we can make some progress for the early part of next week, then that would be helpful.
Yes, sir, I'll do that.
Can we leave it at that then, for now? Go on. Mr. Lane, sorry, forgive me.
Thank you, sir. Just pick up on something Mr. Corsier said. He referred to the extension of Haxby, which I assume he means ST9, and he mentioned that it had not been reassessed as part of the SA process. Well, ST9 has always been an allocation, even in the first draft plan, so it would have been assessed as part of the original SA process. The allocation has not changed in size. The safeguarded land bit has been removed from the allocations, but the allocation itself is the same size as it always has been. So just as a point of clarity and a factual error, I'm sure Mr. Corsier meant another site, and maybe that will be in his submissions, but ST9 has always remained the same.
Thank you for that clarification, Mr. Lane. Mr. Corsier?
Sir, I don't want to bat these points across the table. It's not going to be helpful for you. But the point I'm making is about the spatial development strategy, so not the individual proposal. And it's the spatial distribution strategy, which includes major extensions of villages, such as Haxby, has not been assessed, sir. Not that the individual proposal hasn't been assessed at times.
Are there any other submissions that anyone wants to make?
And this is on issue 1.4.
Okay. In which case, are we at the point of adjourning until the morning? Yep. I think we are this time. Okay. Until tomorrow then. I think, is it a 9:30 start tomorrow? Yeah, 9:30 tomorrow morning then. I'll see you, well, some of you, maybe all of you, tomorrow morning. Thanks everyone. It's been helpful. Thank you, Mr.